Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I'm your host, Maryann Petri, and there is a non-denominational retreat weekend at the Resolution Center of Jacksonville, Florida. This will be a time of support and renewal for parents and grandparents on the journey of parental alienation, standing strong in resilience, paving the way for good health and great future. This will take place on April 22nd through the 24th at the Resolution Center of Jacksonville, Florida. And I will have everything, all the information in the podcast notes. I welcome back Michael Sayen. He was last on the show, season 3, episode 25, which was Err on the Side of Caution, Parents' Constitutional Rights. Now I have him back on for part 2 segment. And we're going to talk about parents' rights versus the children's rights. So I completely welcome you back, Michael Sayen. How are you?
Hey, thanks. I'm chugging along.
Yeah. Thank God it's Friday. That's all I can say. So.
Yes. Yeah. Well, definitely. I have later today in a few hours. I have a meeting with my PTE, which we will discuss spanking, and that is, does the parent have a constitutional and a legal right to spank their child? So that's going to be not a fun type of conversation, as well as other topics, but that's what we're doing. Every time the government gets involved, that's really what we're dealing with, over protection of the government.
Okay. So, with this parents' rights versus children's rights, how, I know when you said the government gets involved, everything gets screwed up, and I totally agree.
Right, because the government
yeah.
really doesn't have any place in the home. It's not to regulate morality and ethics as far as parenting and children, and because really what it is the government's reach is only supposed to go to the adult, and that's where it's supposed to stop, unless in which we've seen King of England. So what happens is, some people kind of wonder, what's the government's place? What is the government's place as far as, I'm sorry, 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 I can't read. Oh, sorry, is it, oh, I'm sorry, is it not coming in very clear? Okay.
It's just, it was kind of distant.
Oh, okay, thank you, appreciate that. Okay, so what happens is, just kind of let you know how how we got our laws from England. And England, so we get common law system. It's pretty much considered a common law system. You have a difference between, or you have two different types of law. You have a written or codified law, or you have a common law. Codified law is more known as a Roman law. That's going to be a law that's kind of, they're written on tablets, right? The 10 Commandments, you got it written down. And then the other thing is going to be common law system. And the common law system is a more flexible system. It's designed to be able to move and to flex. And this is what you're going to hear a lot about, conversations about, is the Constitution a living document or a dead document? Is the Constitution to be read flexibly, to be changed, basically that the understanding and the reading of it kind of changes in time, and that would be called a living document, meaning that it's movable, it's flexible. Justice Scalia wrote a book. He was really famous on writing against the living Constitution, because what he said was the Constitution is not supposed to be read in the eye of the beholder, but it was supposed to be read how it was written and how it was understood at the time. This would be considered a dead document. And the reason why he said that is he said that the authors or founders created what was called amendments. And so if we wanted the Constitution to be changed, we could amend the Constitution. So, and this is a really important thing, because when you're looking at the judges who are looking at the Constitution, and they're making decisions based on constitutionality of laws and of judgments, right, that we bring up, basically to almost like an appeal system. They're looking at this and saying, hey, is this a constitutional law? And so they really have to have a really good constitutional understanding. But liberals have really usually believe the Constitution is a living, breathing document, and that its meaning can be changed over time. Um, uh, the the more conservative type of judges will say, no, it's a dead document. It meant what it meant at the time, and we should look at the historical understanding of words and of certain meanings. So
Mhm.
it's really a big fight. Now, the sad thing is that the Constitution really doesn't affect us in family law. Now, the reason why it doesn't affect family law is there's a important couple of cases why. And if I can kind of go down this track, this will help people understand, where my constitutional rights in family court before we actually separate who has greater constitutional rights, the parent or the child. So what happens is the Constitution came out in 1776, and so the Constitution was a fulfillment of the Declaration of Independence, promised inalienable rights, as well as a document that set up the basic foundation of our government. It was called the Great Experiment. What they wanted to do is give supremacy really to the people, and then have checks and balances on government. The federal government had a was had supremacy, but it had supremacy only in few and enumerated powers. So
Mhm.
it had only a few things. So basically, if you want to look at federalism, what that means is that means the federal government does have supremacy over the state. Now that may sound logical to us, but that's not how it was on the. I'm trying to remember the the document from the states. It was the I'll probably have to remember the name here in a second, but it was actually the document when the states originally started. What they decided to do is they had supremacy to, and you'll see this in their actually documentation, that the states had supremacy, and they created a government, but the government did not have supremacy over the states. It would almost be like a volunteer position, and people would volunteer basically money to the federal government or to the government or federal government, and they would volunteer troops to the federal government. But what happened was it made a very weak federal government. So Federalists said, "Hey, we want a federal government that actually has supremacy over the state. We wanted to have, and then you have what's called the anti-federalists who come in, and you can read
Mhm.
these things as Federalist Papers and the Anti-Federalist Papers. But these guys were actually a couple of authors who went to their local papers, and they wrote to really get support from the local people. And the Anti-Federalist was, of course, against, they were worried about, that type of federalism. And the Federalists wanted to give really more power. Now, it was really a split type of government, which really works for our benefit. And we can really read that today, which is, I mean, it's just really fabulous. So a lot of law professors, and I've been listening to law schools and law studies, they're starting to listen to the Anti-Federalists, because the Anti-Federalists are starting to say, wait a minute, if we give supremacy to the federal government, give supremacy to the Supreme Court and so forth, these are some things that may happen later, and these are some dangers, and such as is that there's going to be, they see the Anti-Federalists saw an abuse of the Commerce Clause. And the federal government really has abused that today. So now the government is too big for its bridges, right?
Mhm.
And if you say, and if you get pulled over by the police, or if you go to court and they says, they'll actually have a running joke, the people in government, and they says, "Oh, do you believe you're a citizen with supremacy, right?" So, and they think it's laugh. Well, the truth is that we, the people, do have supremacy, and those are certain rights and inalienable rights written to us in the Declaration of Independence, which is a constitution, which is actually written in a type of contract. It's a covenant, or it's written in a treaty type language. However, it was meant to have a binding force of the law, because we know that because of the signatures at the bottom of the document, and the promised and explicit and implied promises in the Declaration of Independence. So we have all the meanings of a contract there. Now, when it comes to a covenant, the question is that what is the enforceability, or what was meant for the enforceability? We talked briefly about that. Even though that it meant treaties and covenants were meant to be as an act of war, it becomes the duty of the citizens to overthrow tyrannical government after a long trail of abuses, and to reestablish a new government to be protectors of their inalienable rights. Now, what a lot of times you'll hear in law professors, they'll use this type of language, and you kind of got to be careful. When it comes to a unilateral contract, which the Declaration of Independence and the Constitution is most part. Now, a unilateral contract is when you only have one person promising something to another. So unless there's a conditional clause and other types of things, usually that's considered an unconditional right, which we have our unalienable rights, right? Like, but what they'll say is that, well, a person can't go into a movie theater and can't, yell fire, and he can't use his inalienable rights of free speech, and then all of a sudden people running out of the theater, and people get killed. And so the question is can a person use his unalienable rights to basically affect other people, that affect other people's inalienable rights, right? The right to life and other things, and safety and security. So the government says, well, we need to go in and we need to prevent people from using the inalienable rights and any type of safety issue, right? Now, this is where it becomes dangerous, because when it comes to children, everything that the judge decides can be considered a safety issue, right? So what happens is, and what they do is the family courts do is they use safety and security of the child, and saying that, hey, we have what's called the axis of harm. We have a right, according to the parents' Petri doctrine, that we can take away the parents' unalienable rights if it's for the safety of the child. Now you can really, as you can see, anything that happens to a child, as you could probably imagine, you could say the government could say is for its safety, right? It's for its best interest, and that's really what the best interest was. The best interest, when it was originally decided by the judge. I'm going to go back a little bit in history. Now, according to coverture laws, women lost their legal identity. They took on the legal identity of their husband. That's why a woman dropped her last name and took on the last name of her husband. She became an extension of her husband. She, and such an example, to such a point that she didn't have constitutional rights, and that she wasn't able to, buy and sell land, wasn't able to do contracts, was not involved in and a lot of aspects of the government, was not serving on juries. And a lot of the stuff is actually from the Bible. The Bible law of Moses actually talks a lot about this. And this is called the rule of man, right? Genesis 3:16, the punishment that was upon all women. So going back a little bit further, let me see here. Lost track. Okay, so safety and security. So what the government will always say is that, hey, you have inalienable rights, you have rights that are unconditional rights. However, the only way that the government can really take away those rights is if your inalienable rights affect somebody else's unalienable rights. And in a way, the government say, well, we're kind of a judge in between there. Well, the government job is not to take away our inalienable rights to protect other people's inalienable rights. That's actually not the right way to look at it. The government's job is to make sure that everyone has unalienable rights and equal inalienable rights. So the government is not there to take away your inalienable rights. The government is there to guarantee everybody's inalienable rights. So it's a positive, almost like a positive law versus a negative law, or as a positive way of looking at this, is that the government is there is to make sure that, not to make sure the safety and security of everybody, but to make sure that everyone has a fair shake in this life and in this government. Now, the reason why that's important, because if the government says, well, our job is to protect its citizens, then what's happening is that their power to protect they can always use that power to be able to prevent parents from having any kind of visitation of their child. Even though the parent is still considered fit by common law, they haven't gone through a fitness test with clear and convincing evidence, nor with the jury, and some parents even have their rights terminated, called PTR, parental terminated rights. Is that the parents' terminated rights is because the family court judge uses preponderance of evidence, uses hearsay, and says that a parent is basically not a good enough parent. Now, a judge cannot say that a parent is unfit unless it's with clear and convincing evidence. So that means that family court cannot terminate somebody's rights. Family court cannot take away somebody's constitutional rights that are guaranteed in the Constitution and the Declaration of Independence. So what the government really there is to make sure that everything is even. Now, when we look at, we're going to look at the changing of family law. Family law originally, that during the coverture laws, women and children were under property law, right? As we talked about, women were under coverture law. They lost their legal identity, became that of her husband. If the woman or child did not have, they had very limited constitutional rights. The same with slaves. But the unfortunate part is that the government said slaves were not even people. So they didn't even recognize them as persons having human rights. And this is this is really for the beginning of this history until about 1850. Now, the suffrage movement, the women's suffrage movement, had one desire only when it originally started. It was, hey, how can we free ourselves from coverture law? How can we free ourselves from this? And then they realized that as soon as they free themselves of this, they would be able to have all the constitutional rights of an American citizen. Now, as much as the male. So that means the right to vote, which was given later in the 1930s. The right to divorce equally under equal reasons, and so forth. And so eventually, what the women's suffrage started in around 1840. 1850, they wanted to free themselves of coverture laws. Now, during this time, it was very hard for a woman to actually attain a divorce, being that she was under the property laws of her husband. Now, if she did attain a divorce, or if he actually filed a divorce, he would retain 100% of the children because the children were considered his property. So under the property laws, and women, you'd hear were as chattel. Now, what happened is Caroline Norton, a very famous, really well-known poet and writer back in England around the early 1800s, we'll see around 1830, what she did is she did a private act of parliament. She asked for, she said, hey, we got a human rights issue with children. If the children who, were getting breastfed, and they had a divorce and they were given 100% custody to the men, these children, it's a human rights issue because these children are going to die because they're not going to be able to be, fed. So what she went to Parliament, and she actually did a private act and asked a petition to Parliament for that the mother would have rights, even if she was the one that was guilty of adultery or guilty of cruelty, whatever she was, and she was the one that was divorced, she would still get 100% rights to the child till the child become the age of 4 or until the child was properly weaned, because it was a human rights issue. Now, what would happen is because of coverture laws, even if she was the innocent party, the child would then go 100% back to the father at the age of 4. That the United States got a hold of that. It was a great idea. So then you entered into the younger years or the tender years doctrines into America, to the individual states between around 1830 to 1850. So what's going to happen is that the ages of when does a child become weaned actually starts to fluctuate. It goes from 4 years. In the United States, it goes to 7 years old, stays with the mother 100%, and then eventually up to 9 years old, stays with the mother 100%. And then in England, it shortly went from 1830 to 75. The mother retained 100% under the younger years doctrine until the child was 16 years old. So as you see, these ages started to be longer and longer and longer. And what happened is status quo would kind of jump in. So what happened was, if this makes sense, so even though women didn't have constitutional rights before the 14th Amendment, right, which was the around 1867, so before the 14th Amendment came in, and because the Bill of Rights did not apply to the states at this time, is that men would retain 100% custody, but because of tender years, the younger years doctrines, the women retained 100% custody to start with. Now, as those years started to prolong, we have the next 150 years and the dismantling of coverture laws, women pretty much by the courts were considered that, hey, if you have a young child, the courts would give the child to the parent. Now, that's still going on today. The best interest, now, the reason why men jumped on the best interest of the child doctrine is because they wanted it to replace the younger years or the tender years doctrine, because they realized that legislation always was pushing, for the child to be longer and longer. So even though that, children were under the property rights of the father would not see his child for a very, very long time, if he's lucky at all. So what happens was men kind of jumped on hook, line, and sinker to the no-fault divorce and the best interest of the child standards, thinking that we would get a shake at not only the young children, but all children, and that status quo would not work against men. Does that kind of make sense?
Yes, it does.
Okay, so when we're dealing with the 14th, so what happened was, kind of go back a little bit of history when we want to understand the, yeah, oh, so sorry, thank you. So if we go back a little bit of history, if we want to understand the Constitution and its place with people, is we're going to look at the beginning of the Constitution. We have a case in 1803, Mulberry versus Madison, and the United States Supreme Court, they came to the case that the executive powers and the legislative powers were actually making decisions and creating laws, especially the federal government. Legislators were creating laws that they would say that they said, hey, these are constitutional laws. Now, the United States Supreme Court said, well, those laws are not constitutional laws. So what they did was in a decision of Mulberry versus Madison that was brought before them, the United States Supreme Court expanded their powers, so an expansion of powers. And they said that if there's a question of the constitutionality of a decision, like an executive decision of the president or the legislators who has more power to be able to decide what's constitutional, the United States Supreme Court said, well, we are the deciding factor. So this is called judicial review. And the court says that, hey, according to the power of judicial review, we have the powers to review a law and be able to say if it's constitutional or not constitutional. It's called expansion of powers because they gave themselves the powers to use the Constitution over the other two branches of government. And now this was not a written, now people will use the Federalist Papers and say, well, that was the intent. However, the Federalist and the Anti-Federalist Papers, remember, a lot of those people were the signers and the originators of the Constitution, and even some of them through the Declaration of Independence. So it was a split decision. So even though you read about the Federalist Papers, it doesn't speak for all the authors of the Constitution. And so it was just I think it was just 3 of them, but it was a select few. So anyways, when we're looking at so they said they expanded their powers. Now, and you'll see this on the United States Supreme Court website, you'll see the interpretation of the Constitution. Now, the interpretation of the Constitution, that language should scare you, because during the Dark Ages, the Catholic Church said that they had the power to interpret the Bible. And when they have the power to interpret the Bible, they have the power to basically change the Bible any way they did. And it was during the Dark Ages, and they would tell the people, and it was read in Latin to the people, and they considered the masses uneducated. And that's how come when the Bible was written in their original language, it became such a threat to the power of the church, right? Because they could read it for themselves for the first time, and that people could see that, and they would, and the Catholic Church knew, the authority of the Catholic Church knew that the people would fight against the power of the Catholic Church. And that's where we have the Reformation, or the split between the Catholic Church and the Protestant movement. So the Protestant movement is to protest the Catholic Church. Now, the same kind of thing with the Constitution of the United States. The Constitution was not written in legalese. The Constitution was written for the regular man, the regular farmer, to be able to know his right, to express his rights, and that he would be able to argue his rights. So, but what happens is that they know that there's always going to be checks and balances. The Federals and the Anti-Federalists knew this, so they created a system where they depended upon the frailty of man. They depended on us always to be money hungry, for the government to be money and power, and for people to just people in general to always be selfish. The checks and balances, the system was that the idea was that when one part of the government became too powerful, the other two governments, not out of kindness, but because of their own desire to have power, would fight against the decisions of the other branch because they would be selfish themselves. So they thought this was probably the best way, but they knew that this was not foolproof. So in the Declaration of Independence, they did have the enforceability factors saying that basically, hey, if we become so tyrannical, just like the King of England was for us, we actually give the people the right to overthrow the government and to put it to establish new protectors of our rights. Now, this is what you would be called when it comes to who's the tyrant, right?
Mm-hmm.
Is it the government or is it the people? Now, if you look at the Capitol riots in January 6th, I believe, the Capitol riots, what the government is saying is that the people were the terrorists, right? The domestic
Mm-hmm.
terrorism. So the FBI was involved, and that's how there was such hard prosecution. Because as you know, like the Black Lives Matters, the George Floyd, there was government facilities and police stations that were burned and other things. However, when we looked at the Capitol, what they said, it was an attack on the Capitol, so it was an attack on our government. So they looked at it in a way that, hey, these people are exercising their, with zip ties and so forth, they're exercising their rights according to the Declaration of Independence to overthrow the government. And so we have but because they didn't speak for we the people, but they spoke as individuals, therefore they became terrorists. So the big question is always going to be, who is the terrorist, right? Is it going to be the people who are attacking the government, or is it going to be the government themselves?
Mm-hmm.
And if you're not working with a large enough people, right, then you're not going to be able to speak with we the people. And that's how come even the federal government on the Capitol riots, they says a certain number of people actually have to be involved for them for the FBI. Now, the FBI, you've heard this recently in the school boards, right, where the critical race theory, and you'll hear that parents now are becoming domestic terrorists. And so who are coming in? Not the local police, but the FBI. Right, and the FBI is now saying, well, parents are becoming the domestic terrorists. So if that makes sense, the terrorists, when you hear the word terrorist or terrorism or tyrannical, the question is actually when the government and the people disagree, right? Is the people speaking for all the people, or are they speaking as individuals? And if they're speaking as individuals, they're becoming terrorists or domestic terrorists, and that's how come. But again, this is just a play on words and of understanding, but it's very, very important when you look at the place of we the people being able to stand up against the government or to replace the government. And when the Capitol riot happened, you heard a lot of the people, they brought themselves down to a secure facility underneath the Capitol there. So anyways, long story short, that was the reason that the Capitol riots was looked at so harshly. And that's one of the reasons why it was basically saying, okay, hey, is there going to be a coup, right? Is there going to be an overthrow of the government? And the government said, even though clearly people know that their intention was not to overthrow the government was able to look at it that way to be able to do such hard prosecution of those who were involved in the Capitol riots. Now, going back a little bit, so you have the Mulberry versus Madison in 1803. You also have another decision, it's an important decision, and it's the 1819 decision of, I think it's Maryland versus Monroe. Yes?
Oh, no, go ahead. I was going to say another one, but I was wrong. You were right. Go ahead.
Okay, I think it's Maryland versus Monroe. I think it was 1819. And what this said was it was a particular case of be able to interpret the Constitution. Like when the Constitution language was vague, who has the power to interpret the vagueness of the wording of the Constitution? So the United States Supreme Court says, well, it's our right again. So those two cases are really the foundation of what's called 1819 and 1803 the power, the expanded powers and the power to interpret the Constitution is the United States Supreme Court gave it to themselves. Now, this is why we don't have constitutional rights. And another reason is a old doctrine called stare decisis, right? Let the decision stand. Now, according to stare decisis, you'll hear this a lot on Roe versus Wade. And as we had two of the Republican Supreme Court justices elected during Trump. And what that was is it was a question about what do you believe in stare decisis? Now, stare decisis is let the decision stand. That's kind of the foundation of common law, right? After they make a certain amount of decisions on case law, it become precedents, and does that precedent stand? Now, what's happening is that according to the doctrine of stare decisis, unfortunately, the United States Supreme Court has said if there's an old precedence of a constitutional understanding, but a case kind of comes up that actually says, hey, should be the Constitution should be clearly read this way. Stare decisis always gives the preference. So what the United States Supreme Court is doing is they're using stare decisis to not rule in favor of clear constitutional rights on Supreme Court cases if there's a long history of precedence. And again, that's very dangerous, right? Because the Constitution is under the Supremacy Clause, Article 6, Section 2 of the Constitution, is the supreme law of the land, right? Well, what happened was the United States Supreme Court has said, yeah, the Constitution is the supreme law of the land, but since it's our right and our power to have judicial review and to understand and interpret the Constitution, the supreme law of the land also resides in our decision. You hear this in Cooper versus Aaron, I think it was 1958, as well as many other cases that the United States Supreme Court said, well, our decisions are is the understanding of the Constitution. Therefore, we actually do, our decisions have the power of the Supremacy Clause. Now, that's really dangerous as well, because that's when you get that the former Supreme Court decisions are more powerful and have more force than a clear reading of the Constitution. So what happened was now that really all of our constitutional rights have dissipated based on those two actions, and the United States Supreme Court saying that we speak for the Constitution, therefore the supremacy actually isn't not just for we the people to understand the Constitution, but it's for us to decide what the Constitution says and what it means. Does that kind of make sense?
Right. So they're just kind of making it up as they go along.
Now they come to a point that they can make it up as they go along, and they can use precedents, they can use stare decisis, they can use the power of interpretation, they can use the judicial review doctrines, and they can basically say that, hey, I know that the Constitution clearly says this, but we're not going to rule in favor of the clear understanding and reading of the Constitution. And whenever legislators muddy the water, right, it weakens the understanding of the Constitution. So when people are saying, well, hey, it's been over 200 years since the Constitution was written, and clearly the language is outdated, so if we have to interpret that as well, and they'll say, and then that's to come when the danger of saying, hey, the argument of it, some people say it's a living document and others say it's a dead document. Basically, you're saying, well, the water's kind of muddied, so let us just make our own decision. Right, let the Supreme Court really have that own decision to look at history if we want, to look at the meaning, to look at it in flexible light, and look at it in a changing society. So that was not the intent of common law. Common law was supposed to have some flexibility, but that flexibility was supposed to run under the rule of law, and that you would use prior case, and then you would look at the Constitution, Magna Carta, and other documents, and be able to stay consistent with those decisions the whole time. And we know the Supreme Court has made decisions because it has reversed some of their decisions. I think the Slaughterhouse, you hear about this, when they said that black and whites being segregated from one another, that was a constitutional, they said it was a constitutional law. Then they reversed that law. So it's important to understand how the United States Supreme Court are looked at. Now, the United States Supreme Court is the Supreme Court of the land, so their decisions are supposed to have the authority over all other courts. And then the Constitution is supreme law of the land. And so when you have an officer of the court, such as a judge and so forth, make a constitutional oath, they're bound to the clear reading and understanding of the Constitution. They have a right and responsibility. They actually, if they just the federal government has agreed with this and said that if a judge violates their own understanding of the Constitution and they violate their constitutional oath, they no longer have jurisdictional authority over your court case. Therefore, they can be sued under 42 U.S.C. 1983 of the Federal Code, because the deprivation of rights under the color of law, even though the judges have immunity for doing their jobs, they have full immunity to doing their jobs, the federal government says when a judge violates the Constitution, they basically no longer have a right to be a judge. Therefore, they're ruling outside of their jurisdictional authority, and therefore they can be sued as an individual. Does that make sense?
Mm-hmm.
Okay. Do you have any questions before I go on to the parents and children?
No, go right ahead. It's just, I was going to say that it's just so hard to even sue anybody, you know?
Yeah, well, especially the federal government and so forth, because they've gotten too big for the bridges. And what's happening is there's no enforceability, there's no oversight, especially in the judicial court. And so when you have the oversight was always supposed to be designed that, you have checks and balances. You have one branch of government checking the other branch of government, right? Because it was always about a money and a power grab, and they knew that they would fight against each other. However, when you have an internal checks and balances, those don't work because they still want to give themselves more power. So there always will be a bias if you have a judicial committee overlooking the judges, right? The legislative body was supposed to acquit judges if they were bad judges. So the judicial committee should not be full of judges and lawyers, if that makes sense. It should be filled with people, because then the checks and balances, the basic understanding of checks and balances is not enforced because
Hang on.
making biased umbrella of a liberal organization that has its personal agenda on how laws should look. And they actually, the Bar Association and the family division of the Bar Association is the one who goes to the legislators and who speak against any kind of family reform. So if you're wondering who your enemy is, when you go to legislators and ask for bills to be passed, it's usually two groups. It's the strong women feminist groups, National Organization of Women, other feminist groups, and then also the family law division the family division of the Bar Association. Those are your two enemies. So they're at every single legislative meeting for passing bills, and their job is to do one thing and one thing only, is to stop family reform at all costs possible. So, and then they make up bogus arguments that and so forth and so forth. But they are there to ensure that they have the power and the money, right? They keep the power and the money because it's at an all-time high with no-fault divorce. Well, let me go back a little bit more. So we have the suffrage movement in the 1840s and 1850s in the United States saying, hey, we need to bring down the coverture law. We need to give women to have constitutional rights. We need to give more rights to women. And so also at this time around 1875, we have a socialist factor come in. And under this, you hear about this, I believe this little child named Mary in New York. This is where Child Protection Services and Human Services started around 1875. As a teacher was visiting a home, saw this child malnourished and looked like abused and neglected. She went to the local police and she said, hey, can you guys do anything? And they said, no, since children fall under the constitutional right and the property rights of the father and the constitutional rights of both parents, there's really nothing we could do because most of the abuse and neglect of children is done behind closed doors. So they had a child division of the police departments that would handle this. Now, this teacher went to, and this is all New York, went to a society of two actually individual men who owned, who ran a organization that looked after the abuse and neglect of animals. And the woman says, hey, why do animals have more rights than children? So they agreed, and they actually started a movement to be able to say that, hey, the government needs to be more involved, and rather than just having the police protection, they need to be more involved with the safety of children, because children were being neglected. Now, this is not new. Children were being neglected from England and from 1600s, and you hear about this in Massachusetts. The government has always, under the courts of equity, decided that they are the parent of the nation, and they need to take care of infants and imbeciles. So that was a job of the courts of equity. That what happens was you didn't have people who were aborting their babies as much like you do now. So what they would do is they would take their babies and they would leave it as an orphan at the church door. And the government would take responsibility and would parent the child when there was no parent, right? That's a parent's Petri doctrine, right? The parent of the nation. The nation is the parent of the children. So they became, the nation says, well, the child, these little children that were left in baskets to the door of the church, the nation would become the parent of the child. And what they would usually do is they would start, actually, believe it or not, children work as soon as they could. 6, 7, 8, 9 years old, they were working hard, and so the government was making some profit off of the children, and they were in the factories, they were working. So as long as child labor worked for the government, the government was all about child labor. So and then we also they were in charge of imbeciles as well, and the imbeciles was who did not have the mental capacity to take care of themselves. That would be handicapped, or elderlies, or like no one, where they had no one they could not take care of themselves. They had nobody else to take care of them. So that was the job of that. Now, so what happened was that, and that it ended its way. The parents' Petri doctrine, and you hear about this in 1608 in England. It worked its way through the courts of equity, and then eventually was adopted into America. Now, it was flexible. Now, in America, you have children, same thing, working in the factories at the age of 7, 8, 9. And actually, there was a law in Massachusetts in the 1600s that said, hey, if a parent did not have their child working in some kind of long-term gold, like a career, that the government could come in, take the child, and actually take the child away from the parents, and then give them to other people to make sure that those children are working in a factory type of situation, that they will be able to be productive later in life, right? It wasn't just a job that was meaningless, but it actually. So long story short, the government was the one who was putting kids in the workforce as such. So it was really, really messed up. Now, what happened is the human rights of children not entering into workforce came in, and then this lady in New York tried to say, hey, children should have more rights, and they should have more protections from the government, which eventually the state would help them out. And then when the state helped them out, then eventually the federal government helped them out, and then you'd have state funding and federal funding. So whenever you have state funding or federal funding, you also have state and federal laws or regulations come in to ensure that their money is spent in the right way or a beneficial way. So that's where you start getting in trouble, like the churches taking money or being 501c3 or anything like that. You start getting in trouble when you start either have a free taxation. You don't have to pay taxes to the people, or you actually receive federal or state funds. You're basically opening a door for the federal and state authority or government to come in and use up their authority in that particular situation. Now, the family has always been a protected unit, where the authority of the government has stopped at the front door, basically meaning that the children and women were under property rights under the coverture law. Therefore, the government really didn't have the authority to overthrow the property of the man. Later on, that was divided between the mother and father. However, the government has always tried to push open the door, but that's how come we have the man is the king of his castle, right? You can't come in. You were not supposed to come in without a warrant. But all that was, as he says, to protect the family unit. Unilateral no-fault divorce was created under Marxism in Russia in 1917, and what the Marxism wanted that because they knew that as soon as the family was broken, the government was able to have more control over the individuals, and that the mother would work, and they would have increased taxation of money coming in. So the weakening of the family is always the strengthening of the government, if that
Mhm.
makes sense.
Oh, yes.
So so I'm going to go back a little bit. So when when this particular case of this Mary and this movement to have social to have child protection services, or the history of child protection services, start to be given this funding, right? Then they also started to be given the authority of the government, state and federal government, as well as the monies of the federal government. And as time goes on, they were given more money, they were given more authority, to the point that if you had a child abuse and neglect situation, no longer did you go to the police, right? And they handled it inside their own child division, but they actually came to a point where it switched, and under, it's called administrative law, that the government made a body, right, a governing body that had the extended powers of the government that would go in there, and they would protect for the safety and security of the child, and it would not go through it would not need to go through the criminal system. So what that did was, when that switch happened and Child Protective Services was given more rights, when it was dealing with the criminal law, right, you were dealing with clear and convincing evidence, or beyond a reasonable doubt evidence, because it was looked at as a crime. You had the right to a jury and so forth. However, when the Child Protective Services started to get more money and power from the state and federal governments, and it became a federal law, what happened was you actually see that turning away from the right to a jury and it clear and convincing, or the strong evidence. And then you start to see equity, right, come in, courts of equity come in, parents par doctrine come in. You start to see juries start to go out the window, right? And so when you go to a juvenile court, right, you're not going to see juries. So this is all about parents par, right? The right of the nation to take care of these children who couldn't take care of themselves. And then so basically what they were doing was they were taking children away from parents if they felt that the parents were being irresponsible for parenting their own child. Now this all became over really through the civil courts with a clear and convincing evidence. But however, juvenile courts in the late 1800s, early 1900s, they started switching over to a juvenile court where they were using the preponderance of evidence. And now this is where family law came from. Family law came from the courts of equity and preponderance of evidence and no jury. That came from the juvenile courts in the late 1800s. So family courts were designed around 1917, 1919 through individual states until it became federally protected and recognized. I think it was in the early 1900s. I don't have the exact date, but it started around 1917, and that was a swift movement. So that all came from the parents par doctrine, and that all came from the juvenile courts, or for delinquent kids who were breaking laws, who parents were not considered basically fit to parent their child, and for children who were orphans and left at doorsteps. Does that kind of make sense?
Mm-hmm.
So when we're looking at the really big change when it comes to child's rights, and if we go to like a part 3, I can explain more. But if when we're looking at this as a foundation, and then what happens was the women's suffrage movement saying that, hey, we want our constitutional rights, we want equal rights, and the blacks wanting equal rights for the slavery movements in the early 1800s. The women's suffrage movement jumped on with the slavery movement, and they became almost one big movement, right? A push for equality everywhere, not only for the blacks, but also for women. And so that really transpired when it came to the slave amendments in 1867 is that when the 13th, 14th, and 15th Amendment came in to give the slaves, right, the slave amendments, to give the slaves constitutional rights and women constitutional rights, the women said, well, these amendments apply to everyone, so they apply to us as well. So with the 14th Amendment, they were able to use the Equal Protection Clause of the 14th Amendment to say that we should have all the equal constitutional rights of the man. And they were no longer, women were no longer at the late 1800s, early 1900s, were no because of equal protection of the 14th Amendment. So the coverture law, or at common law, started to change. The judges started to make decisions. And when the women were no longer looked at as property,
right? Then the children were no longer looked at as property. First, it was the women. They says, hey, they're not property, but they have equal constitutional rights. Therefore, the children became the property of both the mother and the father equal, if that makes sense, after the 14th Amendment. Then it said, well, if everything is equal, then children should have equal rights as well through the Constitution, through the equality protections of the 14th Amendment. So then the courts are starting to say, well, if women have equal rights and slaves have equal rights, then children should have equal rights. But the problem is the government says that the children are not mature enough to practice their own rights. So guess who is responsible for protecting the child's constitutional rights? It's not going to be the parents, because remember, the government is taking the children away from the parents. So who is left to be able to decide what the child's constitutional rights are and to fight for those rights?
Yeah,
it'd be the government, right? And that's where you have the guardian ad litem. The guardian ad litems are only supposed to be appointed by law if there's a safety and security question, right? Abuse and neglect, the endangerment of the child. Then the government is supposed to come in and protect the child and give them a child lawyer or a guardian ad litem to be able to exercise the child's constitutional rights and freedom of saying that, hey, their right for safety and security trumps the parents' constitutional rights to parent and their inalienable rights to parent their own child. And that's where we're at today. So maybe if we speak next time, I can explain a little bit more of some Supreme Court cases of how the parents' rights and the children's rights have always been, are now fighting against one another. Instead of saying, hey, the child has a constitutional right to be able to raise by their parent, and the parent has a constitutional right to raise their own children, what the government is saying, no, the parent has the parent's parental rights are not in the Constitution. That was the recent Troxel versus Granville. They said it is fundamental, but it is nowhere in the Constitution. This is, Justice Scalia said this. It says it's an inalienable right. It's not a constitutional right. And you're seeing the courts slowly starting to say, well, the parental rights really are not an inalienable right, or sorry, it is really not a fundamental right that's protected in the Constitution. And they are saying that the child's safety is a constitutional right. So the government has the power to exercise on the parents' Petri doctrine to be able to step in and basically be the child's lawyer, even though that child lawyer a lot of times has never spoken to the child, never asked the child what they want. And a lot of times the child is not even able to voice their opinion with their attorney or even with the court. So.
Right. Or even if the child, even if the child does get to speak, it depends on what the judge and the opposing attorney counsel wants it to be. So they can change around.
Right. And they can say that the child doesn't even know what they want. This is based on not only maturity, a lot of states have maturity ages that they can speak, but judges don't like children to speak in court. But really, children really should not be going through the divorce. They should not be going on the stand. Honestly, you should be looking at the rights of the parent, and the judge's job is not to protect the child, but the judge's job is to ensure, because the Constitution is supreme law of the land, is to make sure that both mother and father have their constitutional rights protected, unless one of two things: they've found guilty of a crime where you can have your liberty right taken away, or they're sued for violating a contract, such as a fault-based divorce, where you would have penalties. And that was the reason why custody was originally given, was based on penalties of the woman violating the covenant, the marriage covenant. I can explain a little bit later how come the women didn't have the same rights as men, but that was really based on religion that was honored through common law and coverture law. But I think that's really all I need to really say at this point. We might not have to have a third. We might not have to have a third. We could probably end it here and just say that's where we're at today. The judges are saying, hey, the family courts are saying, and the appellate courts, the Supreme Court saying that, hey, maybe children have a constitutional rights for safety and security. And they're going to say that trumps the child's constitutional rights to be raised by the biological parents. And we are no longer considered biological parents, but we're considered guardians of our child. And the true parent is actually the nation. And you'll see this deep in our in Supreme Court decisions today, is the parent portrait doctrine is used to supersede the clear rights of the parents.
Definitely. That was so well said. I totally thank you for coming on the show. And again, could you please tell us the name of your book?
Yeah, so my book is not really about family law, but it's about marriage, divorce, and remarriage doctrines of the church, looking at ancient Israel Jewish marriage practices and bilateral and unilateral contract law. It's called Remarriage and Adultery in the Bible, and you can find it on Amazon and Barnes and Nobles. Usually it should be for free as a download, or they can always get in contact with me with my email below, and I can PDF it to you to people for free as well.
That's great. That's great. Well, I'll still have you back on as a guest because periodically we talk. Yes. Okay. So don't jump off. Slam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms. I'm your host, Maryann Petri, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poems of Truth. And again, please join us again here with Michael and other exciting guests. Thank you again, Michael Sayen.
Hey, thank you, Maryann.